Any mention?
Yes.
May please, Your Lordship. Lordship, I beg.
Yes.
Lordship, I beg to mention item number 4. I'm praying that this matter may be come up after vacation. Lordship.
Who's the other side?
My lord, I appear for the respondent corporation MECL. My friend here is appearing for the state.
You are the main respondent.
My lord?
You are the main respondent.
My lord.
You have any objection?
No, my lord.
Okay. On the request made on behalf of the petitioner and not objected by the learned counsel appearing to the respondents, this is matter after vacation.
Highly obliged, Lordship.
Yes.
Your Lordship, I beg to mention item number 5, Your Lordship. I pray that the matter may come up after the vacation, Your Lordship.
No objection, my lord.
Yeah, also same. Just right, same.
Lordship, I beg to mention item number 6. Learned Counsel Mr. S.N. has a personal difficulty. I am praying that the matter may be taken up after vacation.
No objection,
You
Lordship.
have no objection. You see, item number 6. Item number 6, request is made on behalf of on behalf of the private respondent. There is only one private one respondent to adjourn the matter. The learned counsel appearing with the petitioner has no objection. Accordingly, this is matter after vacation.
Highly obliged.
Item number 5, respondent number 1, 2, and 3.
Yes.
Little bit earlier, they were adjourned. My lord.
You want adjournment?
No, opposite party. Already adjourned.
Item 5 has already been mentioned. It's all right.
I'm appearing for respondent number 1, 2, and 3.
Okay, just record his name. Just enter.
May I please, Your Lordship? I beg to mention item number 7 and 8, Your Lordship. I pray for 2 weeks' time, Your Lordship.
You're appearing for?
For the petitioner, Your Lordship.
And for respondent number 5, 6. And for respondent number 4, Your Lordship.
Just quashing. Quashing. You are for the state.
Yes, I'm for the state.
Any objection?
No objection.
Yes, sir, on the request of the petitioner. This is matter after vacation.
Highly obliged, Lordship.
8 also.
Yes, Your Lordship. It's
Same
connected.
player, same respondents.
Same. No, only one private respondent is there. Only one private respondent is there.
Okay.
Notice has been served.
8 also. Same.
Highly obliged, Lordship.
With this, Your Lordship, I beg to mention item number 10, 11, and 12, Your Lordship.
10, 11, and 12.
The arguing counsel, Mr. Purbin, is on sanction leave.
These are all connected matters.
No, Your Lordship. It's not connected matters, but all are quashing.
10 and 12.
Respondents are same in all these matters.
Lordship, we are appearing in item numbers 10 and 12.
My lord, I appear item number 11 for all the respondents.
Your Lordship, I pray for this matter that will come after vacation, Your Lordship.
No objection.
Just say this one. Same thing on the request of the petitioner. This matter after. We just say the learned counsel of the petitioner makes a prayer for adjournment of the matter. The learned counsel appearing with the respondents have no objection. Accordingly, list this matter after vacation. 10, 11, 12, all will be same.
Much
Yes.
obliged, Your Lordship.
Please, Your Lordship.
Yes.
Lordship, I beg to mention item number 3, Your Lordship.
Item number 3.
Yes, Your Lordship.
Yes, what happened?
Lordship, conducting counsel is out of station, Your Lordship. Conducting counsel is out of station, Your Lordship.
They have filed the
You are
affidavit.
there.
They have filed some kind of affidavit stating who are the persons still in service against whom.
That has been signed. But
Yes.
then he's asking for time.
Time by so that hearing could not be taken because senior is not there.
Tomorrow.
2 weeks, well.
So which item will come up?
Any,
No, no, which item will come? Which?
yes, when do you want it? Vacation? After vacation?
My lord.
Hmm?
My lord.
No objection. There are 3 matters, connected matters.
Yes, yes, your lordship.
Same parties. I mean, like the councils are same.
Yes, your lordship.
Okay, just say. Item 16. Mr. Spencer, learned counsel, preparing for the petitioner. Praise for adjournment of the matter on the ground that the learned senior counsel is not available. On the ground that learned senior counsel is indisposed for the day. Prayer for adjournment has not been opposed by the learned counsel appearing for the respondents. Accordingly, list this matter after vacation.
I oblige, your lordship.
Supplement release. Item number 1.
Yes.
Yes, your lordship. Out here, my grievance here is simply because the district council court tried to enforce the letter of CPC in my case. Now, in one of the judgment, it said that I'll take you to that.
Just give a bit factual background. Just tell us that.
Okay, I'll just say it. The district council court said that I'm supposed to go by the provision of Order 9 Rule 13.
Which somehow you are repairing this matter.
My lord, if I respond.
Sit up. Let him say.
Yeah. So what happened, your lordship? When we go by the Constitution, 6th schedule, para 5, sub para 3, it says that the provisions of CPC will not be applicable in the court of district council. So that, which means that we are governed by the principles of natural justice.
Does it totally exempt?
Totally exempt. There's a notification also, your lordship.
What about spirit of CPC?
Spirit of CPC, yes, spirit of CPC.
So which way letters and spirits differ?
Pardon, your lordship?
Which way letters and spirit differ?
The spirit is a right to be heard. I should be given the right to be heard first. So
No.
as long as I can
What
satisfy,
do we mean by
yes, your lordship?
letters of CPC and spirit of CPC?
Spirit of CPC, as long as according to my understanding, your lordship, as long as I am being heard, I have to be heard, because my case is that I have produced the evidence also. Because the case is like this, your lordship.
Anyway, give the fact. What is the matter about?
The facts, yeah. There was a case which was filed by in 2007, an ejectment suit filed by. Yes.
I am a tenant or you are landlord?
I am a tenant in this case.
So ejectment suit was filed against you?
Yeah, was filed against me in 2007. Then against me and my father. So my father stayed in Nongthamai, I stayed in Madanriting. So the case proceeded. Then in 2000.
Where is the suit property?
In district council.
Suit property, the tenancy. Where is the tenancy situated?
It's in Nongthamai.
At Nongthamai.
Yes, Nongthamai.
So who is the tenant there? You or your father?
My father is the tenant. I was like, you are
residing together?
Yeah, no, not residing together. I take care of the property on behalf of my father. My father was originally, but after he became sick, so I was taking care of it. So suit was filed in 2007 against me and my father. So during the lifetime of my father, notice was sent to the address of my father, which is in Nongthamai. So my father used to tell me, there's a case, I have received this, you have to go to the court. Then we used to go together. So what happened after the death of my father, the notice was still sent to Nongthamai. But I stayed in Madanriting. I have stated very clearly, I have made it.
Means you stayed in
Madanriting, right from the beginning.
So after the demise of your father,
yes,
the tenancy become vacant. It's like that tenant, that portion become vacant.
No, there's no. Actually, your lordship, after the death of my father.
This is what? This is a household property or what?
No, it's a property where there's they do the repairing of.
It's a kind of business.
Yeah, business. Yes, Your Lordship. So I filed my application.
Who used to run the business? Your father?
My father and.
Then you also?
Yes, Your Lordship. So what happened? Case proceeded ex parte against me in 2017. Now I filed an application stating, to vacate the order.
Suit was filed in?
Suit was filed in 2007.
2007?
Yes. Then
it means you had the notice, you received the notice.
Yes, during the lifetime of my father, case proceeded.
Yes.
It proceeded, and the reason that it got delayed for so long.
The original suit was filed against both of you.
Yes.
Okay.
Yes, Your Lordship.
So after your father's demise, you remain the only as the defendant. You are the only defendant.
Yes. So notice was sent to my father. After the death of my father, there's nobody to inform me. So I did apprise to the court also when I filed an application for vacation of the order under section 150.
Why notice? You were given notice at the earlier stage when the 2007 suit was filed.
Yes, Your Lordship. Notice.
Why again notice?
Because what happened, Your Lordship, during the what happened in district council, there was some appointment, and then a case was filed against the appointment of judges because there was some.
There was a transfer of the matter from one court to another.
One court to the other. So they had to.
When the matter was shifted.
Yes.
The parties were given notice.
Yes.
And
exactly.
you did not receive that notice.
I did not receive the notice.
Okay.
So when I came to know that the case was proceeded ex parte against me, I went and filed an application under section 151. CPC, section 151 CPC, and then what happened? The decision was against me that it was not allowed.
Why petition under 151? There is other provision below.
Yes, Your Lordship.
Then
yes.
Why 151 should come into play?
Inherent jurisdiction of the.
Inherent jurisdiction can be invoked everywhere. Wherever there is a specific provision in law, can it be?
Yes, Your Lordship. Anyways, for me, it's like the spirit of CPC, like what I'm coming.
Then why 151?
Yeah, 151. Yes, Your Lordship.
Why 151? If you say spirit of CPC, then why 151?
Yes, Your Lordship, because I know that I could have come under the specific provision of district council, but then I applied under section 151.
So you yourself invoke CPC?
Yes, in the lower court. Then when I didn't succeed, I went to the appellate court, and in the appellate court, the honorable court said that you should have come under section under order 9 rule 13 CPC.
Yes.
Which it says there that you have the order 9 rules 3 that appeal can be made against ex parte orders. But my case was not even fixed for there was no ex parte orders. There was no ex parte judgment also. It was posted straight away for ex parte hearing or ex parte judgment. There was no hearing also. No hearing also in this case also.
Without hearing, it has gone for judgment?
Yes, direct ex parte judgment. So which is why I filed for vacating of that order, which I didn't succeed. I went to the appellate court. And
when the suit was ordered to be proceeded ex parte against you, when that order was passed? Which date? It
was passed in 2017.
And when was it fixed for judgment? Give us the 2 dates.
Yeah.
When?
Reserved for judgment, Your Lordship.
Reserved for judgment. This is where hearing concluded.
No hearing. There was no hearing. Directly reserved for judgment. My case is that, Your Lordship, in the first place, I have produced everything. I said that I stay in Madanriting. Right from 2007, it's very clear. The facts are very clear that I stay in Madanriting. Now, after the death of my father, I did not receive notice. I tried to satisfy the court with documentary proof also, which if you've got the last page, Your Lordship, in my last page of that affidavit also, last page of the affidavit, residing at Madanriting.
This is 115, application number 115.
Yes, Your Lordship.
You know we have limited scope.
Yes, Your
Merits may not be considered here. Merits and demerits. You have to confine yourself to the jurisdiction.
Exactly. I'm trying to come to the jurisdiction, Your Lordship. According to the jurisdiction of the under this section.
What is the jurisdictional error so far as this?
Just that the code of CPC was applied in letters.
You yourself invoke CPC. Your present application is also under CPC.
Yes, Your Lordship. But then when the letters of CPC is not applicable
But
in
then
my
you
case.
yourself invoked. Why you invoked 115 here?
Your Lordship, yes.
There is no other provision. There is.
Yes, Your Lordship.
Then you invoked CPC.
Yes, Your Lordship.
So for you can say CPC will apply. For when it is applied by the other side or by the court, you say CPC will not apply.
The provisions of the Constitution say so, Your Lordship.
Then why you have invoked?
Your Lordship, because why I invoke, because I had very strong reason, documentary proof also that
We are not going into all those things.
Yeah, Your Lordship.
We'll not go to the merits.
Yes, Your Lordship. Yes. So that's why my main contention is that the CPC was applied in letters, whereas the provisions of the Constitution says that CPC will not be applicable in the district council. So that is my only case here.
Then you see, you yourself have invoked CPC. You have filed an application under 151 CPC.
Yes, Your Lordship.
Then it's okay. What is wrong in it? There is nothing wrong.
Then I feel that I'll not be heard anymore, because the case has been already proceeded for ex parte judgment without me giving me a chance to be heard.
When it was fixed for judgment? Which date?
2018, my lord.
And now till now judgment it is fixed for judgment.
My lord.
5 years it is taking judgment.
Exactly. Because we have concluded our arguments on 23/7/2018.
There's no
Also thereafter, my lord.
There is no hearing.
No judgment has been passed.
No judgment.
Why? What is the reason?
My lord, the fact is that after a period of 3 years, they were brought again to the court.
I have never
And
heard.
thereafter, my lord, there have been transfer of cases from one court to the other court. So no judgment has been passed. And then
There's
this
no
time
hearing
notices-
also, Your
fresh
Lordship.
No,
notices
if it is transferred, then there has to be a rehearing of the matter.
My lord, notices were served.
The judge who has heard,
Exactly.
if he cannot deliver judgment, and if it goes to some other court, then there has to be a fresh hearing.
My lord, notices were in fact served to both the parties. Then again, the petitioner never appeared before the
Lordship,
court.
the case is posted for cross-examination, not hearing. There was no hearing.
Other
The
parties-
notice was served.
Why you have come here? You have not challenged it before the court of the judge.
Lordship, I did challenge.
Then what happened?
The outcome is, as I said,
This is, what do you say, Rule 28 or what? What is
Rule 28. Lordship.
28? No?
Yes, Your Lordship.
Yes. Then you preferred an appeal.
Yeah, I preferred. an
And then
appeal.
what happened in the
And
appellate
in the
court?
judgment in the appellate court, it says that the rule Order 9, Rule 13 of CPC should be applicable.
Yes.
I have come under the wrong provision of law. So I am challenging that only.
So you could have withdrawn that application, filed an application under Order 9, Rule 13. What is the difficulty in it?
Yes, I could have done that.
Then why you have not done it?
It's already a judgment, Your Lordship.
What is that judgment?
The judgment which is at page.
No, judgment on what ground?
On that the application which I filed under section 1.
Achha, that is
yes.
order passed in your case?
Yeah. In my case, then I made an appeal against the order. So that is the judgment by the appellate court, which says that Order 9, Rule 13 should be made applicable, and I have come under the wrong provision of law. So I challenge that, Your Lordship.
You yourself, you invoke CPC, you invoke wrong provision of CPC. Now you fail to get an order and you come and say that CPC will not be applicable.
Yes. Lordship, I'll just take you to the Constitution.
Then which your court is wrong? You yourself invoke CPC.
Yes, Your Lordship.
Then?
If I may be allowed to read this para 5 of 6 schedule, Your Lordship, I'll just read just.
Yes, read it.
Okay. Para 5, sub para 3.
Yes.
Save as expressly provided in this para. Say it where you want.
Yes.
The Code of Civil Procedure 1908 and the Code of Criminal Procedure 1898 shall not apply to the trial of any suits, cases or offences in an autonomous district or in any autonomous region to which the provisions of this paragraph apply. And Your Lordship, I will also... This is a notification which was issued on September 2022.
By which CPC has been made applicable throughout the state.
No, the CPC is not applicable only in district council. It will not be applicable in the court of district council. Lordship.
This is with regard to CRPC.
CPC.
Subsection 2 of Section 1 of the Code of Criminal Procedure of 1973. This is CRPC, not CPC. This is notification concerning CRPC.
Let me just see. Somehow. I just read this in the first para, Your Lordship. The District Council Court shall continue to derive powers under Section 4 and 5 of the 6th Schedule to the Constitution of
So far as the criminal application of CRPC is concerned,
yes.
It doesn't say about CPC.
Yes, Your Lordship.
This notification has no application in your case.
Okay, okay.
Anyway, you say whatever you say, it is correct. Okay. What is that Administration of Justice Rule 1953? 53. What does it say about the application of CPC? You have? Rule 34. See, you have to come. You can't prepare about the CC, like you cannot expect court to correct all those things.
Yes, Your Lordship, yes. Administration of Justice.
What is that provision which says that CPC will be applicable? Oh, sorry, spirit of CPC will be applicable.
If I'm correct, knowledge Rule 34.
34, yes, it should be.
Mention
Not 34. Rule 47. Procedure in civil cases. You know that provision?
No, I haven't come across.
You study it, come back.
Yes, sir.
Make your case.
All right.
Even then, my lord, before this honorable court, they have come under 115, my lord.
Yes, that is what. Exactly, that is the question.
On the one hand, they are saying no. CPC
He is filing petition right from the beginning till years under CPC. He himself is invoking CPC, and if order goes against him, he says CPC will not be applicable. When shall we have? Next week?
Next week, Lordship.
Come prepared.
Okay, Lordship.
This is quite interesting arena.
Yes.
But then how you put it, that matters.
Yes, Lordship.
Mr. Sangma, we'll have it next week?
Next week, on 15 minutes.
Lordship, not 15. After 15.
After 15th?
Yes,
there will be hardly any working days left for us.
Then maybe next, we can
We'll
have it
try
next
on
day.
19th or 20th.
Yes, yes.
I won't be here, because I'll be leaving.
Not be there.
14, 15 and 16. 14, 15 and 16 I will be out of station.
Maybe on 13 minutes. 13.
We'll have it after vacation.
Yes, after vacation.
On the request made by the parties. List this matter after vacation.
Main list, item number 1.
Yes.
This is that matter where my lords had sought how the writ petition under 226, 227 and 482 is maintainable rather than a criminal revision. This case has got a checkered history, my lord. I can come straight to the law also, but then the checkered history
First, you satisfy how criminal writ petition.
Yes.
The question of personal liberty is not direct.
But this is not a personal liberty, my lord. Rather, there is a direct. This order passed by the trial court is in the teeth of the Supreme Court judgment, as well as the order passed by this honorable court, whereby the IO was directed not only to comply with the direction of giving us all the documents, but also furnish a report as per draft rule 4 of the Supreme Court, my lord.
What is the stage of the trial? What is the stage of the trial?
The stage of the trial is right now the honorable court has recused itself on the ground after passing all these impugned orders, have recused itself on the ground that I know 2 of the accused persons.
Okay, so that matter has not proceeded.
Matter is otherwise at the stage of a discharge. We had come before this honorable court when the court had rejected.
Right, you have to ask for document at this stage, being accused.
But I sought the documents because there was this.
What right you have?
Man, I will show my right.
Show us any
I will show my not only the right, my lord. This is under the Supreme Court, by the direction of the Supreme Court. Every High Court should have, my lord, incorporate this doctrine, which was laid way back in 1963 in America, Brody versus Maryland, and now this has been enunciated by the Supreme Court in Punnuswamy case, my lord. Punnuswamy versus State of Tamil Nadu. This is a 3-bench judgment. I'll show this judgment, my lord. Let's start with the law only. Court master. Yeah. But the right firstly was given to me by this honorable court in the earlier order in criminal writ petition number 2. My lords have the Punnuswamy. I can read from this. This is a death case.
Proper citation for this.
The citation is 2022 SCC online 1543. This has not been reported in the SCC, but the other reportable citations are there, my lord. 2023 1 RCR criminal 307.
What is the relevant part?
The entire judgment is relevant except the dissenting opinion of Honorable Justice Bela M. Trivedi. So 2 is the 2 to 1, but she also concedes that ultimately the accused also got the right to get all the documents, whether relied upon or unrelied upon documents.
At what stage?
At any stage, my lord, rather before the trial commences. This is a departure from the party judgment.
See, documents of what? Documents which are cited in the charge sheet.
Yes.
Not other documents.
These are the uncited documents. Unrelied upon documents.
Where is the relevant part?
The relevant is, my lord, kindly have para 2 only. This is a death sentence case, my lord. The further proceedings, bottom 3 lines from the bottom, my lord. The further proceedings which took place before the High Court, the hearing and the order made on so and so.
You are reading page?
I am page para 2, my lord. First page. First page, para 2, 3 lines from the para 2, my lord. From the bottom, not in the para. The further proceedings. It's in the middle of the para, my lord. Para 2. First page.
Para 2 starts with what?
The para 2 starts with the appellant and some others were convicted under section 302.
Yes.
I would not read, my lord, because this is the death sentence, but what is important is
this is a case.
No, kindly see, my lord, kindly bear with me. It's not like I would have come just to show a death sentence case. The court relies upon there's another, but let's see what this case is all about first. This case was a death sentence. The further proceedings which took place before the Honorable High Court, the hearing and the order made dated 14th of September 2022, declining to direct state to produce documents enlisted in letter returns to the public prosecutor on behalf of the appellant on so and so is impugned here. The final order proposed by Justice Bela Trivedi or rejecting an appeal is in our opinion justified in the circumstances of the case. However, we are unable to agree with the observations made during the course of our order as to the nature of the directions made in suo motu writ petition criminal number 1. This is important. Criminal number 1 of 2017 concerning the right of the accused to be supplied with documents or material seized or collected during the investigation but not relied upon. Then the next para is further important. This I have to read the entire judgment. While hearing a criminal appeal so and so connected matter, concern was raised regarding common deficiencies and practices adopted by trial courts in the course of criminal trial and disposal of cases in the absence of uniform guidelines. This resulted in suo motu criminal writ petition number 1, wherein this honorable court appointed amicus curiae and issued notice to all high courts and governments of all states and union territories, including this state also. So general consensus could be arrived at regarding the need to amend rules of practice, criminal manuals to bring about uniform best practices across the country. Order dated 30th of March 2017 in suo motu, this court noted salient aspects and inconsistencies in the practice and rules of the high courts. A wide consultative process was undertaken. Firstly, high courts and governments of state union territories filed their responses. Taking note of these, the amicus curiae prepared a consultation paper and invited written response from stakeholders. Next, a collegium was convened on 30th of March 2019 to discuss this paper, wherein high courts, governments and states, union territories and police department participated. Based on the feedback, the amicus curiae prepared a report containing the draft rules of criminal practice 2020, which was taken on record on 5 March 2020 and made available, accessed so and so publicly through the Supreme Court website. Before passing direction on the same, this court thought it appropriate to hear the high courts again on these draft rules. See order dated so and so. Once responses were received from all high courts, the matter was heard. In the final order dated 20th of April 2021, reported as criminal trials guidelines regarding inadvertencies and deficiencies in re-state of Andhra Pradesh, reported as 2021 10 volume SCC 598, it was noted that most of the suggestions had been agreed upon except in regard to few aspects. The divergence or additional points of view were taken note of. Para 9. The amicus curiae pointed out that before the commencement of the trial, the accused only receives a list of documents and statements relied upon by the prosecution, but is kept in the dark on other material in the possession of the prosecution, even if it has exculpatory value. On this, the court unequivocally held. Now, this is important. This court is of the opinion that while furnishing the list of statements, documents and material objects under section 207, 208 CRPC, the magistrate should also ensure that a list of other material, such as statements or objects, documents seized but not relied upon, should be furnished to the accused. This is to ensure that in case the accused is of the view that such materials are necessary to be produced for proper and just trial, she may appropriate orders under CRPC 91 summons to produce postal or telegraph authority for their production during the trial in the interest of justice. It is directed accordingly. The draft rules have been accordingly modified. Rule 4 of draft rules of criminal practice, which was appended to and considered part and parcel of this court's order, reads as follows. Supply of documents under section 173, 207, 208 CRPC. Every accused shall be supplied with statement of witnesses recorded under section 160, 164 and a list of documents, material objects and exhibits seized during investigation and relied upon by the investigating officer in accordance with section 205. The list of statements, documents, material, objects and exhibits shall specify statement, document, material and object, exhibits that are not relied upon by the investigating officer. Now, may I pause here for a while? Now, this is precisely why my earlier writ petition came to be allowed. I did not press my other grounds.
Where is it earlier writ petition?
Earlier writ petition is kindly have the order, which is sort of, my lord, my lord, I'll say with all humility, the judge wants to interpret and say the High Court did not meant that. And that's precisely why I'm under 226 and 482. That is at page 335, my lord, annexure. What annexure is mentioned? 10. But rather we should have been, my lord, this matter should have been heard by Justice Dingdo only because he had the occasion to hear the earlier, and my learner friend was also there.
That is also writ petition criminal.
Yes, my lord, that was also, rather but my lords posed that query that was first discussed before the division bench, and division bench, after going through the Bhajan Lal's case, Pepsi home judgment, considered that the High Court rules need to be amended. This particular High Court rule need to be amended because criminal writ petition is not allowed in this court. So we were allowed to file criminal writ petition before this honorable court, and matter was posted before Justice Dingdo because criminal writs are not to be heard by the division bench. And that's how the matter ultimately fell before Justice Dingdo for the entire appreciation of what my allegations were.
Where is the division bench order?
That is, we have not appended here, but that's not the issue right now. Issue before my lords is whether the trial court has complied with, whether all my issues have been addressed, whether these documents can be considered at the stage of discharge are the only three questions which are now to be examined by this honorable court under 226 and 482. Now I'll read this judgment. I need not, the relevant is, I gave up most of my arguments, I'll read nonetheless. Para 3. The learned counsel for the petitioner has submitted that pursuant to the relevant order passed by this court, the investigating officer has allowed the petitioner to peruse the voluminous document and to sort out the relevant document for which copies of the same be given to the petitioners. In this regard, the petitioner has submitted that the IO has had a meeting with them and some relevant document has been identified. However, to complete the process, it takes some time. This being the primary prayer of the petitioner, the learned counsel has submitted that the other prayers would not be pressed. If this court directs the concerned IO to cooperate with the petitioner and to supply the relevant documents and papers entitled by them, in the meantime, until the said process is complete, the proceeding before the trial court shall be kept in abeyance, as was done so by the interim order of this court. There was this earlier order also. Mr. K. Khan, learned senior counsel, I think it is mentioned as special public prosecutor, in all fairness has submitted that the state respondent would have no grievance to the prayer made by the petitioner herein, and to this extent the petition may be disposed of accordingly. On consideration of the submissions made, without going into the merits of this petition, this court is convinced, and this petition may be disposed of on limited prayer made according to the ongoing process of identification relevant documents and papers entitled to by the petitioner, for which the IO is directed to sort out and hand over copies of the same to the petitioner, and on completion of the process be continued, with a report to be filed before the trial court for continuation of the proceeding before the same is completed. However, the IO is directed to complete the process preferably within the 3 months. Now come the impugned order. Kindly have the impugned order also. That is at page 356, annexure 12. This order is dated 26th of June 2023.
Page?
26th of June 2023. Page is 356, my lord, it starts. Annexure 12. Page relevant is 357, my lord, from the top.
Yes.
Other application number 15 of 2023 fixed for orders today. Heard learned counsel for the petitioner Shri D.K. Datta, who submit as per the averments made in the petition, which are follows: that the petitioner CM Jha is represented by his duly appointed attorney Shri so and so, that the documents as per list annexed hereto and marked as annexure 1 are hereby produced before this court in compliance with the order dated so and so, passed by the honorable court in so and so, that all the aforementioned documents were seized by the investigating officer and part of the seized document, but the documents referred to herein above were not made part of the final report under section 173 CRPC. That the answer scripts to each students of each semester were admittedly seized by the IO, but they were not traceable in the Malkhana of CID. Moreover, other documents are not properly kept in the said Malkhana, in the damped and squalid Malkhana of CID. That many documents were not traceable, as the same were not indexed. Moreover, the documents are in disarray in the CID Malkhana. That there is a flagrant violation of rules and norms for the safe custody of the documents in Malkhana of CID. That the documents referred to herein above may be required to be produced as evidence in other cases to defend alleged accused. Non-traceable document kept in Malkhana may be detrimental to the alleged accused, and it may amount to denial of fair trial. Hence, in the circumstances mentioned above, the learned counsel prays that petitioner may be allowed to produce the copies of the documents before this court. Moreover, since the IO in this case has not handed over all the relevant documents and papers to the petitioner till date, also heard Shri Special learned special PP, my learned senior friend, who objects to the application filed by the petitioner on the ground that the document which the petitioner wants to produce before the court already part of the case record. Hence, there is no need for the petitioner to bring them on record before this court at this stage. That YD dated so and so, the High Court and Para has directed the IO in the case to sort out and hand over copies of the relevant documents and papers to the petitioner in completion of the process to be continued, with the report to be filed before the trial court for continuation of the proceedings before the same is complete. The IO is also directed to complete the process preferably within a period of 3 months. That pertaining to the order of the Honorable High Court, the process should have been completed by 10th of November 22. But this petition is filed much later by the petitioner on 13/6/2023 because he has not complied with the order.
Can you go ahead.
Learned petitioner PP also raised objection to the petition being filed by the attorney of the petitioner instead of petitioner himself. On perusal of the petition and consideration of the argument, so and so before this court observed that this instant petition and the petitioner wants to bring the copies of 414 number of documents which are provided in the list marked as Annexure 2 enclosed with this petition. The learned counsel has submitted that the above document intended to be produced before this compliance with the order dated so and so. Hence, this court has to also peruse the said order passed by High Court of Meghalaya marked as Annexure 1. Para 5 and 6 are reproduced. I will not read it. I would not read. It is a reiteration of the Justice Dingdo's order.
No, here you wanted to produce the document.
I'll tell my lords.
What is the order?
I will tell my lords what was happening in this court.
No. What is the order of the High Court?
High Court was to allow them to give me all the documents. They did not give all the documents.
If you have it, why should you want?
But I did not have it.
Then how?
I got it from the Malkhana, my lord. I personally.
How will produce it?
But I can.
In the lower court, you have filed an application.
I filed an application. These are the documents.
Wait.
Yes,
please wait for the court to
very.
See, unnecessary generating heat would not serve.
I'm so sorry, my lord. I will bow down. I will change my. Normally,
no. See, it is understood. It is not that I am not saying anything. You see, now this High Court order never said that a petitioner should be allowed to produce documents.
Yes, my lord.
Now here this petition is 6. Basically, it wants the petitioner should be allowed to produce documents.
Yes, my lord.
Now you say that you have not been supplied with documents. Then how do you have these documents and why should you be allowed to produce documents?
There are 2 questions, my lord. I will answer the first one because there are 2 questions. First one is whether we have been supplied in terms of the High Court order or not. We were not, and that has been spelled out in my application also, that we were not given the entire documentation and the Supreme Court judgment is violated. Justice Dingdo's order is violated.
Given documents. What are those documents?
Those documents are the same documents, my lord, which they should have given me the list. They have not given me the list.
You do not know the list. What has not been given to you?
That's precisely, my lord. Even my lords, my learner senior friend was that day was relying upon the.
Now you say you have not been given a documents. Then
the entire documents.
Now then, what do you want to produce before the court?
The documents which were given to me so that I can rely upon them. Because, my lord, those are the underlying documents.
Have not been given to you.
Yes. But there are 2 sets of documents. One are the set of documents which I relied upon and were given to me. I mean, some documents were given to me in pursuance to the order of Justice Dindo.
Given to you and which are not been given to you.
Though that's precisely, my lord. If you that photographs, there were photographs. My lord, I personally went to Malkhana to get this document. They are all torn up. I said, where is the master index? Master, my lord, may call for the. I can only say call for the record.
What record?
The record. Where is the master index? Master index of all the files seized by them. Call, my lord, call upon them and cat will be out of the bag.
Whatever has been seized, it will be given, provided with scissors.
If they would have been given, I wouldn't have been here. If they would have been given,
then what has not been given to you? Tell us.
But they are not being given. The kindly see, I don't have they did not give me those documents. Kindly have the master
documents.
They're all sets of documents, my lord. The entire
identify the documents.
But how do I identify the document?
You do not know.
Let's see, my lord. But
you cannot say nothing has been this.
I will factually, my lord, put it in a better way.
Complete the trial court's order.
Very well. This.
What you want, you do not know.
But I know what I want.
You do not know, then tell us what you want. What is
I want all the registers, my lord, the original registers of the attendance sheet.
Tell us what are the registers.
The attendance sheets of all the students. Attendance sheet of all the teachers.
From which period to which period?
The impugned period from 2010 to 2013.
Was it seized from you?
They were seized from me.
How do you say? On what basis you are
Because
saying?
they were part of the master index which I signed.
Where is that master index?
They don't have, they say, let's see, my lord, because...
Anything like that, master index and all those things, Mr. Khan?
So for what has been submitted in the charge sheet in the trial court, yes. In the trial court, the charge sheet was submitted.
Yes.
There, yes. And that copy has been given to them.
No, what basis are you saying that some documents...
I am also at a loss, Lordship, if you can clarify.
But then if you do not know what order this court will pass?
Absolutely. Lordship, if you recollect also, when Honorable Justice Dinglaw passed an order, I considered that so far inspection is curtailed. That is under 20...
That is what the law also provides.
207.
Inspection. Yes.
Lordship is correct. And then the other provision is this: if there were some documents, Lordship is aware that Section 91 of the...
Now here this application, by the application which was filed before the trial court, the petitioner desired to produce some documents.
So that is the Lordship.
No, I kindly have my second para 5 also.
One way he says he has no document, he has not been given a document. Other way he says he wants to produce some documents.
That is precisely the point. Lordship, let him clarify that.
I can clarify, my lord, in case my lords want.
No, definitely we want from you.
That's
Nobody
what
else will come.
Kindly have kindly come back to page 357.
Absolutely.
My application.
And you just complete reading this order.
Very well. On para 17, 359, my lord, page 359.
Yes.
On the bare reading of the above mentioned paragraphs in the order dated so and so, what this court would humbly understand is that through the said order, Honorable High Court of Meghalaya has directed the IO to sort out and hand over copies of the relevant documents and papers entitled by the petitioner to him, and on completion of the process to be continued to file a report before this court for continuation of the proceedings after it's completed. There is no report filed by the IO before this court that the process of sorting out and handing over relevant documents and papers to the petitioner is completed. Moreover, the learned counsel of the petitioner also verbally is submitted before this honorable court that the IO has not handed over all the documents to the petitioner till date. On order dated so and so of the Honorable High Court of Meghalaya does not direct the petitioner to submit any document before this court. Moreover, the learned counsel for the petitioner has not submitted anything to the provision under which this court can accept production of any document on behalf of the petitioner at this stage when the trial of this case has not commenced, as that in consideration of the observation made above, the instant petition is hereby rejected and stands disposed of.
What is wrong?
Now there is two things are wrong, my lord.
What are the things?
Kindly have I'll go back to the Honorable High Court's Justice Dingdaw's order. Justice Dingdaw directed that the complete process be preferably within completed 3 months. That period got over, my lord. They did not give me any document. Secondly, my lord, I said they have not given me the documents. All the documents which they have seized. The master index of the...
Please give us what are the documents and which are not been given to you.
What has happened in this? My lord, first let's go back. I will make sure my argument is good, my lord. When they seized the document, they created a master index for all the seized documents.
That we do not know. That you are saying.
Man, I can't say anything because I personally went and saw that the CD which had the entire and the...
You want us to go by your statement?
My statement is very good at the bar, my lord. The IO has to be then called here whether...
You file a petition in your name.
Then I can only submit to this honorable court that there is no compliance of one. They have to... Yeah, these are the documents which have been given to us. Lecture 11 are the documents which have been given to us.
Then which documents are not given to you?
The documents, because these are incomplete documents given to us.
And then this petition, basically, you sought to produce some documents which has been rejected by the trial court, saying the trial has not begun. That is not the stage to produce. So what is wrong in it?
But there are two things which are wrong, Malad. Again, I come back to
what are
Justice
things? First thing you said that no document was given to you.
Man, I never said that no document was. These are the documents. Kindly see my application again.
You see, just arguing for the sake of argument.
I would not do that. Man, I don't do that ever.
Till now, this court has not. The court is unable to make out what your case is exactly.
Very well, man. I'll make out my two arguments. My first argument is that the documents which were seized in 2013 at the time of seizure, an entire master index was generated. That master index has not been given to me.
Where is that master index?
I don't have it. They emptied my entire university.
Which way this court will determine this?
I know, my lord, the inquiry has to be then conducted. And kindly see, I've got another.
Without any basis, we will not go for any inquiry. There is no question. You show us something prima facie.
Like, I fail to understand. If the state takes away from me, and I say all these.
At least you will know what has been.
I am telling my lords, I told the trial court also, they have taken all the registers, the original registers.
What are the register identify? What do you mean by all the registers? 100
But they have taken the hundreds of registers.
How many hundred? How much?
They have taken the entire truckload. But there are 3 rooms full of in the Malkhana.
You do not know how many.
If a court commissioner is appointed, he may go to the Malkhana and see from bottom till top. There are documents and there is no list. And then I got a second argument, my lord.
Not at all. You do not know what documents have been seized.
I don't know, my lord.
You do not know. You see.
I know all my documents also. But what good is it if I know my documents? Because this honorable court also doesn't want to believe me. How do I prove a document has been taken? Something is taken away from me.
You are not given a copy of seizure when the seizure is made from you.
The seizure, the list which is, this particular charge sheet was given after 3 years, right up till the Supreme Court I went.
At the time when seizure was made, you have not been given any.
I know not. Because I was,
why you have not insisted for that? You are entitled to a copy.
Kindly see, in the seizure list also they changed the entries and the court allowed.
Where is that entry?
Kindly see the High Court judgment, where the High Court, this honorable court records.
You said they have changed the entries in seizure list.
Yes, the High Court records. And High Court says go back to the trial court and agitate all these points which were agitating before me. And when I go before the trial.
High Court has not given any finding on that.
Kindly see, my lord, I will be, my lord, I'll be completely, my lord, it would not be incorrect for me to say that this honorable court came through.
Any objection you want to fight this application?
Have page 56, my lord. This is the High Court order. This honorable court passed an order. Firstly, this order, and then I'll come down to the second order also, passed by this honorable court in this very petition. This is in criminal petition number 29 of 2015, criminal petition 33 of 2014.
Page 56.
Page 56, my lord. This starts at annexure 7, my lord.
Yes.
Chandramohan Jha versus state.
It's not legible, sir.
The legible is next, my lord. I think the typed copy is at page 56A. Kindly have that. This order shall dispose of both the matters, namely criminal petition and so and so, as they relate to the same trial pending 130 in the court of CJM. Shri N.D. Chollai, learned counsel for at the very outset submit that this is the warrant case triable by magistrate. Thus, the petitioner can take up all the points and arguments which he has raised in this petition before this honorable court. Thus, he suggests that it would be more appropriate for the petitioner to withdraw the petition and plead all the CJM had directed handcuffing of the sons of petitioner in the breach of law laid down in the handcuffing by Honorable Supreme Court and change the entry of rupees 88 lakhs to 8 lakhs in the seizure memo at the instance of the investigating officer without holding an inquiry, and the matter is remitted back to the trial court. Then I come back to...
What is the finding that has been done? See, what is the finding?
Then I have to go back to the trial court.
Is it the finding of the court what you have referred just now?
Mr. N.D. Chollai says.
What he says?
It is his submission, and then the court says.
No, Mr. I do not know which way you put it in order.
Then the matter is remanded back, and I file my application there. This is a quashing petition, my lord, of the entire matter against me. And the last, to raise the
IO has not
without expressing any opinion on the merit of the contention, grounds, question or law raised in prayer.
Just a minute, hold on. This, as per the earlier direction, on completion of the process, IO did not file any report.
IO filed it. Lordship, I had given you the
That
copy.
should have been done.
Lordship, it has the copy is there, Lordship. On the last day, I had given the order.
That's the post facto. This is the
Lordship, 17/8/2023. Actually, a single page.
Yes, yes, I did.
That's the 9th August.
17th August.
17 August.
My order is 17th and the report is 9th. Much after the impugned. Have his first pair also, my lord.
Kindly hold for a moment. Why are you so impatient?
I'm so sorry, my lord.
So it speaks of compliance. And it has been complied with, so what remains?
Kindly have the first pair, my lord.
Yes.
I would like to bring to your notice that CID so and so has been endorsed to me for further investigation.
Yes. So?
There is no further investigation, my lord, directed.
That is a different issue.
And kindly thereafter, my lord, see.
That you challenge at the later stage. Anyway,
I challenge that. My lord, I need to challenge this report now. I challenge the main order. Kindly see on what grounds I have challenged. Now my second ground is still there.
What is the second?
My second ground is writ large, my lord, on the bias.
What bias?
Because, my lord, I have produced all the documents. The trial court does not allow me to, my lord, put it on record, nor says I will consider those documents.
No, how can, see, trial court says that is not the stage.
That is the stage. I will now come back to the judgments. Now the Supreme Court, now the law. If my lords don't want to hear me on facts also.
No, we are not shutting
That's
you
why
down.
my lords are shutting me down, because my lords are putting me down by saying that I need to first of all identify all the documents seized by them. They did not give me the seizure list.
If you claim something, it is your
I am claiming, my lord, even if the inquiry is held, my lord, it will be found that they created the master index and they did not give me all the documents.
There is nothing only on your statement, nothing on that.
Very well, then the law only. I'll read this judgment, my lord. This judgment, which is Punnu Swami.
Mr. Khan, you will find an objection to this application? Do you intend?
Okay, Lordship.
Yes, heard Mr. Sohel. You should notice. Returnable in 3 weeks.
My lord may stay the trial court.
Not stay.
I'll tell my lords why. Kindly have this order. But she now recuses herself on the strength that she knows the accused person.
Which order to be stayed?
My lord, the trial has to be stayed now. Kindly have this order which has been given to my lords 30th of November. She recuses herself and she is the person who is, my lord, passing the orders, impugned order.
What is the stage of trial now?
Discharge.
What is the stage of trial now?
Copies and
charges yet to be framed. I have to, my discharge application is pending.
So you go pursue it there.
Without the I will pursue my lords also for stay. Kindly have this another judgment.
Which order you are seeking stay? Which order to be stayed?
The trial.
The Lordship,
the last order.
What is the last order?
The one I was just reading, my
26/6/2023. That is basically the impugned order.
26. What is to be stayed here?
Lordship, in 26/6, the trial court observed that this is not the stage for consideration of the documents.
Para 17, my lord, is the one which I am to file report before this for continuation of the proceedings before after it is completed. Now the process will start, my lord, without my discharge will also get dismissed.
And now, Lordship, what has happened? The matter was fixed on 30/11/2023. So that order is not part of the criminal retribution.
Yes. She recuses that she knows the accused persons.
So now, basically, what my learned friend is
So
submitted.
trial is not proceeding.
No, what my learned friend basically she recused and she transferred it to another magistrate, and the next date is on 15/2.
But before that, she has already passed those impugned judgment, impugned orders.
Basically, if I understand my learned friend correctly, he is putting an allegation of bias against the judge. If the allegation of bias against the judge comes to Lordship, then she has to be implicated as a party. A very serious.
I will read that.
A very serious objection has been
This court has observed that two accused persons, namely Shri Tilak Das Gupta and Shri Mrinal Kanti Dev, are personally known to self. Hence, to avoid any conflict of interest, this court deems it fit proper to recuse itself from taking up the trial and disposal of the incident case. And once she was already married, it is not like she did not knew them earlier. She knew them earlier and she passed those two orders and bailable warrants also.
Have you taken these grounds?
Man, I could not because this she recused herself on.
We are not going, you see, not going.
Man, but this court is under 226.
Mr. So-and-so, Learned Counsel for the petitioner, issue notice and returnable in 3 weeks. Mr. K. Khan.
SPP, Your Lordship. Special Public Prosecutor.
So-and-so. Appears for this, along with so-and-so appears for the state respondent. List is matter after. Have you say return for 3 weeks? We say okay. So-and-so appears as such. No formal notice is called for.
No, she is.
Okay. This is matter after 3 weeks.
My lords, may record my submission of with regard to recusal. My lord, I'm pressing that also, and kindly otherwise rejected. However, my lords may feel the order dated 30th of 11th.
No, what is your prayer?
My prayer, kindly have my prayers also. D holds whether I prayed, my lord, under 226. This honorable court, while uphold,
you file an application.
Yes, my lord, I will file, my lord, that also. Direct and set aside the order, pass any order.
It's all right, court has passed the order.
My lord, may kindly record my submission that the honorable court has now recused itself.
Yeah, we should notice that didn't come. That reply comes.
Item number 2.
Man, there is another judgment. Man, I will.
Court has passed order.
Then my lords may reject that the trial may not be stayed.
Where is the prayer of stay?
Man, may kindly, I am making a prayer, man.
If you file an application, then the question of rejection comes. Otherwise, no.
Man, normally, my lord, in 226, the honorable court normally, my lord, hears on all grounds, my lord.
You go if you feel aggrieved, you can take your action.
Not that I am disagreeing. I am just saying that my submission may be recorded.
No. Yes, who is appearing in this matter?
When allegations were writ large.
My lord, with due apology, I have to submit that the steps have not been taken because, my lord, I had been out of station entire month. Meanwhile, the juniors left for home without taking steps. I came to know today by seeing the files only. I may be given just 3 days. I'll take steps, my lord. By Friday, I'll take steps.
Okay. The office not take. Oh, Mr. You are appearing, Mr. You are appearing person.
Yes.
One should not be in attire.
I was out of station for the entire month actually. I was on leave also.
Check your dress, Mr.
You have to take off your gown.
Oh, yes, I forgot that.
You should not do it in the courtroom also, Mr. Mr. P.K. Bora, appearing in person, submits that step due to certain difficulty, the steps for service of notice upon respondent number 2 to 8 could not be taken and prays for grant of some more time.
Just 2-3 days will be enough.
The pair has not been opposed by the learned counsel for the respondent. Accordingly, the petitioner shall take steps for service of notice upon the said respondent number 2 to 8 within 2 days.
Yes, ma'am.
This is a matter after vacation.
Yes,
Nice.
Yes.
Item number 9. 13.
May it please your lordship.
Yes.
Lordship, before my senior start, your lordship, this is a case of quashing of a such-heated case, your lordship.
Yes.
We do not know, your lordship, what is the stage of the proceeding before the learned trial court?
This is a case instituted which year, Mr. Sulai?
Lordship, this is in 2000. The charge sheet is there, your lordship. This is 2017, your lordship.
Oh, then
FIR 2017.
2017, your lordship.
FIR 2017, yeah.
Then the charge sheet has been filed. The date is not there.
Charge sheet.
17/2020, your
Page
lordship.
1819, my lord.
So what is the stage of the trial then? Because statement has these are all statement. The statement which you have appended, these are 161 statement?
Yes.
Okay.
But this, the fact of the case is such that your lordship that.
But then if you do not know, say supposing it is already disposed of then?
No, my lord. I am very much there. It's still pending.
What is the stage of
It is for CC. Constitution of charge.
The senior counsel says it is for CC.
Yeah, for CC.
If that is the means,
No, it's very much there.
What is the grounds on which you are seeking quashing?
May please, your lordship.
Yes.
The story in short, I will be very, very short, my lord, because we have already heard of this matter also. There are two villages, my lord, Umpanai and Lamlair, my lord. And these two villages, there were a dispute. And that dispute ultimately has been settled by the aim of Khairim, my lord, when he has disposed the matter. And when he has disposed the matter, everything is there, my lord, in the.
Yes, please continue. Please continue.
You
can continue, sir.
When you have disposed of the matter, as a matter of fact, the dispute is a boundary dispute, my lord. A boundary dispute
between the complainant and the accused.
It is not a complainant. Subsequently become like that.
Complainant village and
yes, and the accused village. So both of them are headman, my lord. This is in the capacity of the headman only, this matter. Then the boundary dispute has been settled, and then all the subsequent cases pending before the district council also have been settled on the basis of the written agreement. And thereafter, my lord, we have filed a petition. Then, however, my lord, before that, there was a domestic water used by both villages, and that water source, my lord, it was given assistance by the community CD department. And thereafter, my lord, because of the dispute, so there was a misunderstanding, and there was damage to that water source. And the FIR was lodged by the Umpanai village, my lord. And on the basis of that, inquiry has been made and charge sheet has been submitted. But however, my lord, since everything has been...
Where is the FIR?
FIR is on page 18 and 19. 18 is and the type copy is page 19, my lord.
Is lodged by one Janshan Kharkangar.
Yes, my lord.
Sardar.
He is yes.
He's a party here.
Yes,
yeah.
The FIR is like this,
You are supporting the case of the petitioner.
Compromise. Everything has, there is no dispute whatsoever now. The FIR, my lord, may I read your lordship?
And then who were booked after this affair was lost? How many accused?
How many accused? The then head man and his follower, my lord. Total 8, my lord. But that head man died during the pendency of the case, my lord. And all the subsequent...
Now petitioners herein, they are all accused.
Yes, they are all accused. And this, my lord, this water source is in the private land in my village, my lord. That is in page 80 and 81, my lord. 80 is a type copy is 81. And the boundary dispute, my lord, which has been settled is since 27/01/22, my lord. It has been completely settled, my lord. And that is in page 80, my lord. Boundary dispute settlement, my lord, is on page 80. And the type copy is in 81. How do you do it? I have to email. That is agreement, my lord. The type copy is 81, my lord.
Page
81. 81. After 80. Okay.
So there is a settlement with regard to boundary.
Yes, boundary.
But then that is not directly connected with lodging of FIR.
It's connected, my lord, because this is the cause of all the dispute, my lord. It is the cause of all the dispute, because when this boundary has been...
That is according to you. But then, so far as the criminal proceeding is concerned...
I'm satisfied for that part, of course, I have to satisfy your lordship.
No, is it required that we go to that extent? This is basically, you are seeking quashing on the basis of some compromise.
There was a compromise.
So this agreement is not regarding compromise. It doesn't say so about this.
No. This just to show that this is a cause, my lord. Yes. And this cause has been...
then after the consequent to the FIR, the charge sheet matter was investigated upon, the charge sheet was filed. And against how many accused?
8 accused, my lord.
8 accused.
And the fact remains, my lord, also, that in similar cases also...
Just a minute, Mr. Charge sheet is here. Is it appended here?
Yes, my lord.
Where is that? At page?
Lord, you will find it at page 29, Annexure 7.
Any compromise.
Annexure 7, page 29, Your Lordship. Lordship, kindly turn to page 30.
Yes, 1 minute.
9 people all together, Your Lordship, have been
One died,
such-
my lord.
No, as per the charge sheet.
The compromise kind of page you got also.
Is it page 30, Mr. Shule?
Lordship, yes. The final report at page 29, Lordship, the name of the accused are detailed in page 30, Your Lordship, as serial number 11 of the charge sheet. The name of the accused, Your Lordship, till page 34 of the charge sheet.
Yes, there are 9 accused.
9 accused, Your Lordship, yes.
One died.
Who died?
Kleinpor.
He was the then headman, my lord. Under his leadership, this thing happened, my lord.
This charge sheet is filed under section. Four 47, 427, 34. Read with
Yes,
section
my
3, prevention of damages to public property.
All these have been is a compoundable offence, my lord.
Damage to property, yes.
Only this one under
If it is
the
compoundable, then why you are here?
No, my lord. Only this one under the public damage to property.
Okay, that is not compoundable.
That is not compoundable. So, my lord, thereafter there was after this charge sheet, there was a compromise, and that compromise, my lord, is in page. 89, my lord. The compromise, my lord, is on page 89.
Yes.
It was made on the 21st day of August 2023, my lord. After all the cases have been withdrawn and everything, between the headman of Umpernai, my lord, and the headman of Lamdale, my lord.
No, the compromise is signed by how many persons?
By the
not all the accused.
No, my lord, by the headman themselves.
No, how can they represent? In criminal case, there is no system of representation.
But my lord, this is a dispute between the two villages. It's not a
In criminal case, we can understand that, but then in criminal case, you see, the responsibility is always individual. The concept of representation is not there, unlike a civil law. If there is any agreement that has to be signed by the person concerned, this agreement will not bind them.
It's bind, my lord, because they have signed also.
No, they are not named as party.
We are party here. I am representing the complainants, the original first informant, and all the accused are also parties here. Now we are considering there is a compromise.
See, we can understand your thing, but then see, like in criminal law, It cannot be. Accused cannot be represented by anybody. This is one thing. Now, if you say that yes, you being complainant, you withdraw from prosecution. You avail 321, go to the trial court.
For that matter, all the petitioner, they are the petitioner in this petition before before Honorable High Court, my lord.
But then this agreement has not been signed by them.
But this agreement is between the two bridges.
No, but then that is the basis, you see, of your filing of your case. That is the basis of filing of this case.
Because the content also of the compromise was like that only, manner. Whereas accused number 9 is a headman, and as such is competent and authorized to swear this of it on my behalf, on behalf of all these.
No, we understand that. See, understanding on personal capacity and the requirement of law is something we cannot record that they have come to a compromise in view of the fact that they are not a party.
But the
it
fact
is essential before this court passes any order, either accepting or rejecting your prayer, at least the court has to come to first finding that there exists a compromise application. There is absolutely compromise agreement, sorry. That is what is needed.
Of course, for that there will be no problem also to file and that line.
In that case, you avail other things. I think there is a provision in CRPC where prosecution can withdraw. Now, 321, I think.
321, yeah.
So that is what. If you say you convince the prosecutor there, and you file an application before the court, take permission and then withdraw. Because this court is basically would not like to go with this compromise application. It is not signed by the parties.
Or in the, if I could not convince prosecution, then at least I have to file a petition, compromise of all the accused then.
That also you can do. You can prepare an application, file on proper these things. I see, this is option given by the court. This will not be reflected anywhere. But then this agreement has to be signed by all the accused. If you want that agreement to be acted upon by this court.
Regarding washing, non-compoundable offence or going, it's something like a lead of West Court. There is no other provision. Now, the West came up before the Supreme Court when the payment is to be accurate. Now, they have laid down the parameters. No way, it's not speaks about settlement. It's not saying that it should be a written.
Settlement in a criminal case, what it would mean?
Settlement has been sorted out within the party.
You see, Mr. Sen, tomorrow one accused may come and say that I am not a part of this settlement.
Or he is a petitioner.
All of us are party before the court, my lord.
He is a party.
Agreement, you see, no, you see, settlement in a criminal case would mean the parties, they are in their side.
What is settlement in criminal case? Compounding. That is the settlement. So far, criminal jurisprudence is concerned, my lord, compounding. Now, here one section is non-compoundable. So we could not have settled it before the trial. That's how, my lord, we have come before this court, my lord, they have come and invoked the jurisdiction.
So we understand. Even compounding is what? Between the parties.
Between the parties, their signature and
See, if you go for compounding, assuming that this is a compounding offence, and you go to the trial court, headman cannot go and represent the accused. The accused has to be there. So even if you take that line, adopt that line, that essentially it is a kind of compounding, since there is the provision doesn't allow you have come to High Court, then you have to go by that. Even in compounding also, can a headman represent the accused? Cannot.
But they are a petitioner before this court.
Agreement. This is talking about the agreement. See, your petition has been filed basing on the agreement. What is the problem? You execute another.
A written agreement signed by all is not required. When all the parties are before the court in 480.
So show us any law.
I think that law has been laid down by this law basically on Washington. That is 2014 6 SSC.
Thereafter also 2019 there is a judgment. This is a two-bench judge. See, 2019 judgment will be by 3 judges. There was a difference between 2012 and 2014. 2014 says that when offence is non-compoundable, offence cannot be compounded. 2012 Supreme Court allowed compounding in a non-compoundable offence. Now then 2014 I think it says that the recourt has to be by filing 482 application seeking quashing. Okay. Now these two differences, you see, in 2019 state of Madhya Pradesh versus something.
Yes, madam.
Probably earlier also this court had given you that indication. See.
Yes. All those things have been referred, madam. That's why I would like to refer.
This court has reservation with regard to this compromise. See. We cannot record it as a compromise attained by the parties, complainant and the accused.
What your lordship is insisting that there should be a written compromise. My humble submission.
See, there should be, basically, if you say that compromise is the base of your application, then there has to be. That is the basis.
The quashing is based on that only, on the basis of the compromise.
It's not only on the
basis by the parties.
It's not only in the basis compromise because they are part and parcel of that dispute only. And the guideline of the apex court also in that line only, my lord.
Apex court never said that this is the compromise.
No, only the.
This has to be, can be signed by any other person. See, Mr. Kinjing, we all know that concept of representation is not there in criminal law. By no stretch of imagination we can say that.
But in this case, my lord, the guideline has been given by the apex court also.
Guidelines? Once there is a compromise, the guidelines will apply. Once there is a valid and acceptable compromise. If court is not willing to accept some compromise, then if you say, basing on this thing, that there is a averment in the thing, then you say like this averment basically is not correct in view of the fact that agreement has not been signed by this thing. You talk about this, that boundary dispute has been settled by so and so, and then
the subsequent cases that go with them also has been already quashed, my lord.
Now, what do you say in paragraph 13? Just see. 13 and 14. You say petitioners that they have amicably settled. The petitioners respectively so and so. But then, wait, their signature is not there in the agreement.
But on the basis of that agreement between the two headmen, my lord.
So that is, the petitioner is not
because the cause of all the matter is that thing only.
No,
and that thing has been settled.
No, this court will have to satisfy, see, these things, it own conscience before it comes to this thing. See, court has to see that there exists no compromise. Now you say that in paragraph 13, the petitioners and so after a thorough discussion about the subject matter has decided to bury the hatchet and they amicably resolve the things. But then there is nothing, the petitioners are not there in this compromise. Then paragraph 14, these petitioners respectively submitted that they have amicably settled.
But the content of
by a compromise. Now you are compromised. But now in this compromise you are not a party.
My humble and respectable submission, my lord, is that they are very much party because they were.
The document doesn't say so, Mr. Kinjing. I can understand what you try to say, but then understanding on personal level and understanding in a court proceeding are two different things.
And this is, as a matter of fact, trivial matter only. It's not a big thing also.
Your agreement and your averment doesn't go together.
However, my lord, the fact remains that this is it's not a heinous offence.
Whatever it is, you have this compromise first. If you have to correct it or you have to file another compromise, if whatever you do, or you can avail 321, it's up to you.
In that case, we'll have to find ways and means, my lord. Either
definitely, you can enter into another compromise. duly signed by all the parties.
Then that case we will do like that.
Petitioner is agreeing.
You agree because we are because
Ultimately, the issue of settlement. Because we also want to. We are neighboring villages.
Definitely.
What the term settlement has been used by the others. No way in say it should be a written. It should be a compromise deed signed by all. I don't know. But Lordship may have reservation. That is all right.
That's
when all the parties are before the court.
Have you filed an affidavit? Have you filed an affidavit in this case?
I'm making a submission on instruction.
Have you filed an affidavit in this case?
You can also once I can file that.
No.
On inspection,
Oh, see, this is one thing is that the averments and the agreement and don't go
I
to.
have some reservation on this, but the fact is this: all parties are here before the court, and we are saying this has been compromised.
Now, if that court has served reservation, it is not required to be cleared. We withdraw, file afresh.
Okay, madam. We don't.
What do you say, Mr. Sulai?
Lordship, I have reservation regarding this observation, Your Lordship. Since they are withdrawing, Your Lordship, I will not make my submission.
No, they are basically sort of compelled to withdraw. They are not in a mood to, but then
Yes,
seeing the court thing. But then I do not know what is the difficulty. Why you are insisting? If you are compromising, if you are in a mood to, then you can enter into another compromise. Why are you insisting that it should be accepted?
Only thing I was saying, no way it doesn't say that it should be a written compromise deed and signed.
No, then settlements. The settlement.
The settlement was never made.
Where that has been elaborated?
Settlement has never been made.
Where it has been elaborated?
When all the decisions, there's a settlement. No way it says that it should be a compromise deed.
Then it's all right. In absence of that, we take it as a written settlement. And when the petitioner is willing, you being responded, why you are complainant, isn't it?
Informant.
This has been. That's why, my lord, I'm saying this has been sorted out.
Whatever it is.
Because in the compromise also the content is very clear, my lord.
That is all right. But then let it be signed by all the accused. Then we'll see.
Though I am the respondent here, because I am also keen, my lord, this should be sorted. This case should not go on. Because since the matter has been sorted out, we can find a small affidavit, my lord, and if your lordship wants, my lord, it should be a compromise deed signed by all, my lord, we can enclose and place it before my lord.
No, that will be separate. Then this agreement will be dated subsequent to the filing of the petition. Arbiter case King, London Senior Counsel for the petitioner. Also Mr. Andy Shulai, Learned AG, and Mr. Shen for the private respondent. A perusal of the documents, particularly the agreement appended with the writ petition, particularly what you said, the deed of compromise, appended with the writ petition, shows that the petitioners, those who are accused, have not signed the same. It has been submitted that the headman of the concerned village has signed the same on behalf of the accused. Stop. Since it's a compromise in connection with criminal matter, it is the requirement, it is the normal requirement that the accused should sign the compromise, if any, by themselves. and not through any representation. Come on. In view of the matter, London Senior Counsel for the petitioner seeks permission to withdraw this application with liberty to file a fresh. Prayer allowed. The petition stand dismissed on withdrawal with liberty as prayed for.
Apply.
Apply.